Okay, welcome to the Her Justice video training on uncontested divorces. I'm Laura Israel Sinrod. I'm a senior staff attorney at Her Justice.
And I'm Anna Ognabeni, also a senior staff attorney at Her Justice.
While you're watching this video, you're going to want to make sure that you have the latest version of our manual in front of you, because we will occasionally refer to page numbers in the manual. And the manual also contains a bank of sample documents that represent two common client scenarios. And you're going to want to refer to those sample documents to understand the various pleadings and forms that are required for an uncontested divorce. Our objectives today are to understand how Her Justice works and how the mentoring process functions, to understand some basics about uncontested divorce, which is essentially a divorce that's done just on paper, to review some basic elements of matrimonial and civil procedure law, and to talk a little bit about the challenges of working with clients who are in poverty or are emerging from a crisis situation, as many of the Her Justice clients are. And we're going to walk you through in sort of an overview format the necessary documents and filing procedures for doing this type of divorce. So Her Justice is here to help you with any strategic questions that you have as you do your case, to talk about your client meetings, to review all drafts before they're filed and before the case is initiated. And you should also be using all the resources of your firm to answer questions about filing procedures, civil procedure in general, firm policies about retainers, and the general pro bono program. But do come to your Her Justice mentor with any questions that require our expertise in family and matrimonial law and in working with clients who are living in poverty. So all uncontested divorces in our program should be filed in New York County, unless you have a compelling reason to do otherwise, and you can talk to your Her Justice mentor about other options. New York County is Manhattan. We have pre-screened all the clients in the program to make sure that they meet the residence requirements in the domestic relations law in New York State. So typically, our clients have been living here in New York for 2 years continuously prior to commencement of the action. Sometimes a client has been living here for less than 2 years, but her spouse has been living here for 2 years, and that's fine. Or she's been living here for 1 year, plus has some other reason that she meets the residence requirement, such as the grounds occurred here, the marriage occurred here, the parties live together here in a marital residence. So if there's less than 2 years continuous residence by your client, you'll want to talk to your mentor to just confirm that the client meets the residence requirement. And know, too, that although we do screen all clients for Domestic Relations Law 230, the residence requirement, sometimes things change between assessment and placement at your firm. So this is the kind of issue that you're going to want to double check with your client before you commence an action. Clients are free to file in any county. As I said, we recommend New York County, and the county of plaintiff's choice is designated under CPLR 509. You can also use CPLR 503 to designate that the parties are filing in a county where one of them or both of them live. So in New York, you can file for divorce using what we call no-fault grounds, which means that the relationship between the parties has been broken for at least 6 months, and only one person needs to think that the relationship is broken for these grounds to apply. So we do have some clients who come to us and want to use alternate grounds for divorce, such as abandonment or cruel and inhuman treatment, which is known sort of informally as the domestic violence grounds for divorce. And we really do recommend that everyone use no-fault divorce in order to guarantee that the case stay uncontested, at least as to grounds. So if your client has not been married for 6 months, then these grounds might not work for you, certainly won't work for you. Let us know. And if the client is really committed to using alternate grounds, that's a good strategy discussion to have with your Her Justice mentor.
Okay, so we talked a little bit about where to file and the grounds to use for divorce, but now I'm going to talk a little bit about what we call the ancillary relief that you'll be seeking in the divorce papers. In other words, aside from just dissolving the marriage, what else might the client want to be seeking in her divorce case? And uncontested divorces through the Her Justice program are very specific. Because they're uncontested, they can be done on the papers. The client does not have to go to court. She does not have to see her husband. They tend to be quick and easy, we hope, as compared to a contested or litigated divorce where the parties have to go to court, see a judge, have multiple court appearances, exchange discovery, etc. However, because uncontested divorces are decided only on the papers, they limit the issues that your client can seek in the divorce matter. So an uncontested divorce can seek custody and visitation with minor children of the marriage. You can seek child support under certain circumstances in an uncontested divorce. You can also ask for the child to be covered by health insurance. You may continue prior family court orders that the client already has before filing the divorce. You can ask for family court to continue to have concurrent jurisdiction over issues after the divorce is over. And the client may resume her prior surname after the divorce is granted. If the client asks you during your initial meeting or at any other point during your representation for other relief, then please call your mentor right away. For example, if she decides that she wants the parties to have joint custody of the children, if she wants spousal maintenance, which is New York's term for alimony, in other words, support paid to herself aside from the children, if she wants health insurance for herself, or if she reveals that there might have been assets acquired during the marriage, for example, retirement accounts or a home that she wants a judge to divide for them, those are not issues that can be decided on the papers in an uncontested divorce, and you should refer back to your mentor. Just a note, these are specifically Her Justice practices. There are ways to get an uncontested divorce and still seek things like maintenance or equitable distribution, but within the Her Justice pro bono program, we don't consider, for example, drafting a stipulation between the parties to be an uncontested divorce through our program. So if the client asks you for a stipulation with the husband or anything else that doesn't fall under our definition of an uncontested divorce, please do call your mentor and we can discuss it. So specifically with regard to custody and visitation, this must be addressed in any divorce where there are children of the marriage under 18. Typically, the children in a Her Justice case are going to be living with your client, and she is going to want sole custody of the children, and then the father, the husband, is going to get some kind of visitation or parenting time. Sometimes the parties have already been to family court, and they might already have an order from the family court that lays out the custody and potentially a very specific visitation schedule, etc. If the client has a family court order, you can simply continue the family court order in the divorce. It doesn't have to be addressed de novo. If there is no family court order and the client thinks that the husband will not contest the divorce on custody grounds, you can state in the divorce papers that the client will have sole custody. With regard to visitation, typically you must also include a provision as to visitation. Discuss with your mentor the language that works the best in your client's situation. Sometimes you would say the father will have reasonable visitation. Sometimes you are a little more specific that visitation shall be as mutually agreed between the parties. So take a look at the samples that we have in the manual that you've been provided with, and if you have any questions, discuss with your mentor. The only time that you might be able to leave visitation blank in an uncontested divorce is if the client and the father have been through a custody case in family court and the father either did not seek visitation or he wasn't granted visitation by the family court. In that case, you could just continue the family court order of custody and leave visitation silent. One note about custody and visitation is that if you're seeking that in the divorce, then the court is required by statute to run what's called a registry search. And so if there are any orders of protection between the parties, or if ACS has ever filed an abuse or neglect case against either the mother or the father, those cases are going to appear in a registry search, and the judge is going to want to know more about that situation from the parties. And so it's better to get out ahead of that issue. Make sure that you know from your client if there have been any orders of protection, even temporary ones that were never finalized. And if ACS has ever been involved in the family, make sure that you understand what happened and whether something was ever filed in family court. If that has happened, don't panic. All you have to do is make sure that you reveal everything in the papers when you submit it, and typically it means that as long as it's been revealed, when it turns up in a registry search, the judge will still sign off on your divorce unless something very unusual has happened. Child support also must be addressed in an uncontested divorce, but contrary to custody, which is up to age 18, child support must be addressed if there are children of the marriage under age 21. So you might find yourself in a situation where you're seeking child support but not custody, for example, if the children are between 18 and 21. There are a couple different ways to do child support in an uncontested divorce. The easiest way is if your client has already been to family court and gotten an order of child support from the family court that is less than 3 years old. If that's the case, you can simply continue that child support order and you don't have to do any calculation. It'll just stand. This can also potentially have happened if your client receives cash public assistance. Any person with children who goes on cash public assistance, the Commissioner for Social Services typically will file a child support case on their behalf. And so if you find out that your client receives cash welfare, you should ask if the Commissioner filed for her, because it may be that there was a child support order already entered that she didn't have to participate in the case for. That might not have happened if your client is a domestic violence victim. If that is the case, then she might have told the Commissioner not to pursue the father for child support if it was unsafe to do that. So just find out what your client's situation is. If there's no prior family court order, then child support must be calculated using the child support worksheet, which is one of the documents that you will submit with the packet of papers to be signed off by the judge. The best way to fill out the child support worksheet is if you have proof of the husband's income and it's on the books. So for example, if the client has access to his most recent W-2 or a couple of recent pay stubs or his most recent tax return. In amicable divorces, the client could ask for this from the husband, or it might be that they split up only recently and they filed taxes jointly last year. She might already have a copy of that. So find out if she has that. If she has his income, then you can do the child support worksheet, follow it through step by step. There's a sample in our manual, and the child support worksheet is also available on the court website, so you should take a look at that. And then child support will be calculated using a percentage of the father's income, and the percentage varies depending on how many children there are in the marriage. If the father either has zero income, or his income is completely off the books, or if he's been missing for years and the client has no clue what his income is and it's unsafe for her to ask him what his income is, then you can fill out the child support worksheet but put down that his income is zero or unknown. If you put that his income is zero or unknown, then the minimum amount of child support that will be payable is $25 a month or $300 a year. Just be careful doing this, because there are some cases where judges in Manhattan have rejected papers where the husband's income is marked as unknown. If that happens, then you should be prepared to explain to the judge why the income is unknown. So again, the examples I gave were if the husband has been missing for a while and it's impossible to ask him for his income information, or again, if there's been domestic violence in the marriage and it's unsafe for her to ask for his income information. Those are two things that you can explain. Of course, if he's incarcerated, then his income is going to be zero. And so what I recommend is, if he's incarcerated, then just write a little note on the child support worksheet that his income is zero, and then incarcerated, and that will take any questions away from the judge's mind when reviewing your papers. As part of child support, there is also an obligation for the parents to maintain the children on health insurance until they turn 21. So this must be addressed in some way in the divorce papers. If there's been a prior order of child support from family court, then the family court will have addressed the health insurance issue, and that means you can simply continue the order. If you're calculating child support according to the worksheet, then you have to have some paragraph in the divorce papers about who's going to cover the child. So find out from your client who is covering the child right now. And of course, if the child is not covered yet, the client must arrange for health insurance before the divorce. Many of our clients, because they are low income, have their children on the state provided health insurance or Child Health Plus. If that's the case, then that is free to the client. There are no out-of-pockets, and so it's fine to simply continue that. Less frequently, the child might be covered by the father's health insurance through his employment. If that's the case, then usually there will have been a child support order ordering that already. But if the child is covered under any private health insurance plan, either from your client or from the father's employment, then there will also be a provision in the divorce papers about how the parties are going to divide the out-of-pocket expenses. So this means co-pays for things like prescription, doctor's visits, etc. If there are out-of-pocket expenses and they need to be divided, the division will be by pro rata share, meaning that each party will pay according to the amount of their income, and that will also be calculated on the child support worksheet if you're doing that in the divorce papers. If the father is paying the minimum amount of child support, either because his income is zero or unknown, then there will be no pro rata share for him, even if your client has out-of-pocket expenses for health insurance. If your client has children under 21, then in addition to asking for custody, visitation, and child support, you'll also seek in the divorce for the family court to have concurrent jurisdiction with the Supreme Court. And this allows the client to go back to family court to adjust the judgment of divorce, the child support amount, the custody arrangement or visitation arrangement if she needs to in the future. Especially if the children are young, then there might be many years of custody, visitation, and child support to come. And so you should preserve her right to go to family court instead of having to go back to the Supreme Court. And finally, in a divorce, you can seek for your client to have the right to resume her prior surname. We always include this in all divorces, even when the client tells you she never changed her name, or even when the client tells you that she did change her name but she doesn't want to change it back. Those are fine because the way that the language is phrased in the divorce is that the client may have the right to resume her prior surname. This preserves it for her and it takes away any questions or doubts just to make sure that there's no problems in the future. You can advise her if she's worried about it that she does not have to change her name, but she may change her name, and so it really does need to be included.
Okay, now we're going to talk a little bit about managing your case. And you're going to want, as I said, to have our most recent manual in front of you so that you can look at some samples and some flowcharts and other documents that we have in there. As I said, every attorney who works on a Her Justice uncontested divorce has a Her Justice mentor, one of our staff attorneys, and you can consult with us about questions you have with regard to managing the client's expectations, running meetings with the client. We'll review all your drafts. But again, you also do want to harness the resources of your firm and ask more experienced attorneys or folks in the managing attorney's office for assistance with filing procedures and other internal procedures over at the firm. I'm going to direct your attention to page 2 of our manual where you'll see a helpful flow chart that describes sort of how the mentoring process works. I always tell our volunteer attorneys that when you ask us for an uncontested divorce, you should be prepared to meet with the client within 2 weeks of receiving her file. If not, sometimes clients' circumstances change, their contact information may change, conflicts with the spouse may arise, and so it's important to be timely about starting the case to avoid complications down the road. And overall, these cases are an exercise in timeliness and precision, getting your careful, tailored drafts past the clerk's office so that they can be signed quickly by a judge and all the parties and their children can move forward to the next chapter of their lives.
Can I jump in, Lauren?
Sure, of course.
In addition to all the things about circumstances changing, one of the biggest reasons to be really timely in meeting with your client and initiating the divorce very quickly after you get the file is because service must be accomplished on the husband, and you never know what's going to happen. If he's in jail, he might get released. If he's living somewhere, he might move. If he's undocumented, he might be deported or leave the country. And if the client can no longer serve him, then she cannot get a divorce through our uncontested divorce program. And so it's really important to keep that in mind when planning out your divorce case.
Absolutely. So you'll receive a case file from her justice. It has contact information for the client, some basic information about the sort of posture of her case, whether there are children, what kinds of waivers she signed, what type of ceremony she had for her marriage, and you'll want to review the file. And if you have any questions about the file itself, just contact your Her Justice mentor. And right away, you're going to want to schedule your first meeting with the client. And this is, one of the places where it's important to be sensitive to poverty issues and domestic violence issues. So, just as an example, you may call your client and say, how about coming in on Thursday at 3 o'clock? And the client will not be comfortable telling you, actually, that doesn't work for me. That's when I pick my children up from school. Because she's been, coming out of a relationship where she really had no voice and no autonomy. So a more sensitive way to schedule the first meeting would be to say, I'd like you to come into my office. It's in downtown Manhattan, and I'm going to give you subway directions. Where will you be coming from? What's your schedule like? What days of the week typically work for you? And keep it a little more open-ended. And on that front also, it's nice to meet the client in the lobby of your building and give her very specific instructions about how to arrive, where the security desk is, and where to meet you and what to bring. Typically, you won't actually need your client to bring very much because we will provide you with the most important documents that allow you to verify the date of the marriage, the spelling of everyone's name, et cetera. So again, refer to the flowchart on page 2 of the manual. It shows you that shortly after meeting with the client, you're going to want to put together drafts of the initial papers. Once you've interviewed her and confirmed that all the information in the case file is still accurate and that she understands, the parameters of your representation, she's signed the retainer with your firm and has cleared conflicts, and you'll send your drafts over to your Her Justice mentor for review. Once we have reviewed, and it can take, a little while for us to get to the papers, so, do allow about 2 weeks to hear back from your mentor. Once we've reviewed, we will provide a fee waiver letter so that the fees associated with initiating the action will be waived because you're working with an indigent client. You'll then file the initial document in your case, which is a summons with notice, and simultaneously purchase an index number, which is the identifying number for the case. And at that point, the clock will start ticking on the 120 days that you have to serve the spouse in your case. And we're going to talk a little bit about service later in the training.
All right, now I'm going to talk about drafting the initial papers to start the divorce. And while I'm talking, as Laura mentioned before, we recommend that you have our manual in front of you so that you can refer to some of the samples in the manual. In our manual, we've provided 2 sample sets of documents. One sample set is for divorces without children, and the other sample set is with children. The sample papers for no children begin on page 18 of your manual, and the sample involving children begin on page 46. However, you should not just copy and paste these samples because there are many different variables that occur in a divorce matter, depending on what your client's situation is. And so just because we've divided these sample sets into 2, no children and children, doesn't mean that these samples are one size fits all for no children and children divorces. So the best way to draft your papers, and we strongly recommend that you do this, is to use the software that we use at Her Justice called Drafting Libraries. Many of the firms that we work with already have licenses to this software, and so chances are you already have access to this. Check with your pro bono partner or with your IT person to see if you can get Drafting Libraries on your computer. If your firm doesn't have it, we do strongly recommend that you ask to buy a license. It is relatively inexpensive, and again, it will make the drafting of this so much simpler for you. Even when you use Drafting Libraries to create the documents, however, you should still go through the documents carefully to make sure that they make sense, they're internally consistent, and that they do match everything in your client's situation.
And also just make sure that you run an update on Drafting Libraries before you start using it. There are frequent updates, and so if you did an uncontested divorce 6 months ago, there's a good chance that there are changes to the software, and your IT person can help you with that.
So Drafting Libraries is available at draftinglib.com. The link is on the slide that we're showing now, and it's also in your manual. The other resources that you can use is on the court website, the New York court website, and the link is also here and in your manual. They have blank forms of every document. They're a little bit less visually pleasing, and they're a little bit more complicated to use, but if you find yourself with no Drafting Libraries, then you can use those forms if you choose. There are a couple of documents that I'll discuss later in this training that you actually must go to the court website to download, because the court will only accept fillable PDFs of a couple of the documents. But aside from those couple of documents that you need the fillable PDF, everything else that you need to create, almost everything else, can be done in Drafting Libraries. There's a couple of exceptions that we'll discuss in this video, and for those exceptions we have provided samples in your manual, and so you can copy those samples. Initially, when you meet with the client, you should find out whether she's a victim of domestic violence, and if so, does her abuser know where she is living now? If he doesn't know where she's living right now, then it may be unsafe for you to put her address in the papers, because if her address goes in the papers, he's going to be served with the summons, which is going to have her address on it, and he's going to be served with the judgment of divorce, which will also have her address on it. If your client is a victim of domestic violence and wants to keep her address confidential, she has a couple of options. The easier and quicker option is for you to help her enroll in the New York State Department of State's Address Confidential Program, or ACP. We've provided a link to the Department of State website, which has the forms and also a brochure that you can print and give to your client to explain the process. But basically what the Address Confidential Program is that the Department of State will provide your client with a P.O. box in Albany, and the court is required to accept that P.O. box in lieu of her residential address on the court papers. Then, whenever she receives mail to that P.O. box, it's essentially a forwarding service, so any mail sent there will be forwarded to her. So it's really important that she always keeps her actual address up to date with the Department of State so that she can get her mail. She should also understand that because this is a forwarding service, it is going to slow down the delivery of her mail. Now, when you're representing her in an uncontested divorce, she doesn't have to worry about things getting served to her at her P.O. box address, because if anything were to be served in the context of this divorce case, it's going to be served on you, her attorney, anyway. But this is a free service, and all she has to do is fill out a form and sign under penalty of perjury that she is a victim of domestic violence, and she'll be given this address. The downside of the Address Confidential Program is that it does not protect her Social Security number, and her Social Security number must also appear in the divorce papers. So if she's afraid that her abuser is going to use her Social Security number either to find her address, or if he's been financially abusive in the past, he might use her Social Security number to fraudulently apply for credit cards or monkey around with her credit. If she needs to keep her social confidential as well, then you have to prepare a motion. The motion can ask for her to keep her address and her social confidential, or only her address, or only her social. It just depends on her situation. But basically what the motion consists of is a blank order that a judge is going to sign for you, and it's going to be accompanied by an affidavit from your client stating the facts of her case and why it would be unsafe for her to have to put her address and or social security number for either herself or her children in the divorce papers. So look at your manual. Our sample motion papers for the address confidential motion begin on page 112 of the manual. And for the affidavit, you'll see that you do have to be somewhat specific, but you don't have to be really, really long and specific. So it's generally sufficient just to allege a couple of instances of domestic violence that explain to the judge why he's unsafe. If she has an order of protection against him, you can include that order of protection as an exhibit. You don't have to. But basically just something relatively recent and specific that shows that she has a credible fear of revealing her location.
And those motion papers are not submitted to the same place as your divorce papers. So they are filed at the Supreme Court simultaneously with commencement of the action, but they go to the ex parte office, and the opposing party will not have access to the supporting affidavit that describes the domestic violence. So the client should not be fearful of describing the incidents in any particular way or in a way that may upset her spouse.
Mm-hmm. Once you have the address confidential order signed by a judge, then the husband does have to be served with that order, but as Laura just mentioned, he does not get the supporting documents, but he does have to get the order. All right. Aside from the address confidential papers, the other initial documents that you'll be preparing are listed in your manual, and they're also listed on the slide here. So for an initial round, her justice mentor wants to review a summons with notice with the accompanying notices, a verified complaint, an affidavit of service, an affidavit of defendant. If your client was married in a religious ceremony, you have to prepare a sworn statement of removal of barriers to remarriage, which will be served on the husband with the summons. And then you will prepare a cover letter to the husband explaining the papers, and if he's incarcerated and you're asking the correctional facility to serve him, you'll prepare a cover letter to the correctional facility. Send all those to your mentor to review. Before you send them, again, whether you've used drafting libraries to create them or whether you've worked from our samples or the court website, please make sure not only that everything is internally consistent so the relief requested is the same throughout all the documents, but also please make sure that everything that your client needs to be addressed in the divorce is addressed in the summons with notice and in the verified complaint. Because once the summons with notice is served on the husband, that is the relief your client is getting. She cannot ask for something additional in the judgment of divorce or something different other than what was in the summons. So it's really important to be, as Laura mentioned before, very careful and meticulous and accurate and consistent. Even if the client tells you that he's probably going to sign the affidavit agreeing to the divorce, as a best practice, you should prepare an affidavit of service. Because if something happens, if he changes his mind or if he never gets around to it or if he doesn't fill it out correctly, if you have an affidavit of service, you can still proceed with the divorce. Likewise, even if she thinks he won't sign the affidavit, there's no harm in preparing one and sending it to him anyway because he may surprise you. And finally, on the list of initial documents, we've included the Child Support Standards Chart. This is printed off the court website. It changes every year, so make sure that you're printing the most recent version. Your mentor doesn't have to review this because it is just a PDF, but if there are children of the marriage under 21 and you're using the child support worksheet to calculate child support, the husband must be served with this, and that's why we include it in the packet of initial papers.
Okay, now we're going to talk about serving your initial pleadings on the spouse in your case. So service of process in a matrimonial action is personal service. Anyone can serve in New York as long as they are over 18 and not a party to the action. Service should not be affected on Sunday or on another day of religious observance. So if Saturday is known to be the Sabbath day that the opposing party observes, then don't serve on Saturday. And 120 days is, again, the deadline for service after the index number, that identifying file number, is purchased for your case. And, service, as we, sort of hinted at before, is the, I think, biggest stumbling block in moving an uncontested divorce forward, because we can only go on the client's, good faith belief, credible belief that she knows where her spouse is. So the spouse may change locations, maybe, as Anna said before, released from prison, maybe deported, or maybe traveling for an extended period of time and just not at his regular address. So it's important to be timely. It's important to build in some wiggle room into service so that you're not stressing out running up against the 120 days. And again, this is a point to discuss with your mentor. If the opposing party is not at the location that the client believed he would be, then please let us know. We can work with investigative firms like Kroll to do searches for alternate addresses. We can give you some ideas for strategies just from our own experience about places that you might find the spouse, like a common hangout or a place of employment, maybe another family member's home. It's not required that the spouse be served where he lives. It's just that he be personally served. So we'll talk through that with you, and if service is becoming impossible, we'll also talk through the possibility of an alternate service method and seeking the court's permission to effect service in some other way or upon another person, like a friend or family member who has regular contact with the spouse. So again, this is a good point of contact with her justice mentor, to talk through some possible strategies.
And just to jump in, typically as a best practice, it's much easier for you and for the client if you can use your firm's process server to serve the papers, not only because it's easy and it's safer, but also because they're used to doing this and they'll fill out your affidavit of service correctly. There's going to be no question that they did it according to the law, etc. There might be a couple reasons why you either can't or don't want to use a firm process server. For example, if the client thinks that having someone in a uniform or a stranger show up at his door and hand him some papers is actually going to trigger him to react badly, then it might be better if a known friend or family member does the service instead. Consider the opposite way. If your client is telling you, oh, my friend can serve him, it's no problem, but you know that there's a long history of physical domestic violence, you may want to encourage your client not to put your friend in a situation where being served with papers might trigger a violent reaction, and you may want to consider using a process server or maybe even a sheriff in that situation. So talk to your client about what her husband is like and how she thinks he's going to react to being served. Many people react in strange ways that you don't predict. And try and figure out with your client what is going to be the best and safest way to effect service.
And so if you're using a friend or family member, someone who's not a professional process server, take a look at pages 12 through 14 of our manual. We have instructions that we hope are helpful to a layperson in understanding how to fill out an affidavit of service correctly. You might even have the person come to your firm to have their affidavit of service notarized, and you can check it to make sure that it's complete. Common error, for example, is not listing the exact address where the person was served. So those are all things that you're going to want to check on the affidavit of service if it's filled out by someone who's not a professional process server or may not speak English. It's fine if they don't speak English, but you'll want to give instructions that they understand. And if the spouse is incarcerated, the correctional facility will take care of service for you. You should still send the blank affidavit of service with a self-addressed stamped envelope for the correctional officer. And we have sample cover letters in our manual that explain to the correctional officer who the inmate is that needs to be served. You should identify the person by their inmate ID number that's available on the New York or whatever state they're in, correctional facility website. And I also find that, especially with some of the prisons upstate, it's helpful to call them. People really do answer the phone. It's a little bit surprising, I think, if you've never called a correctional facility before. But often you can actually get the person on the phone who's going to be effecting service. It might be, for example, an officer who works in the law library at the prison, and they'll know to expect your papers, and they'll be more likely to honestly, to send you back the proof of service. They might also give you an alternate address from what's available on the prison website, in my experience, or at least a person to put the papers to the specific attention of. That'll help your case move forward a little more smoothly.
As Laura mentioned, service of process is one of the things that can hold up your divorce the most. And so one of the most common questions we get from clients when we're assessing uncontested divorces for placement is, how long is my divorce going to take? The answer is always, it depends, but it most often depends on how quickly he can be served, because everything else depends on service. Nothing is going to move forward until he's been served with the initial papers. And so again, this is an area where you should be paying attention and following up, making sure this is happening, not only because there's a deadline for service, but also because the quicker he gets served, the quicker your client's divorce can be finalized.
So once the papers have been served, there's a few possible avenues for the uncontested divorce to progress along. The defendant may sign the affidavit of defendant that you prepared in your initial papers that was reviewed by her justice mentor, and that's just a consent to the divorce. The divorce can then move along as soon as you, as counsel, have the affidavit in your hands, and you'll prepare the final papers along the guidelines of it being a waiver on contested divorce, and you'll see that noted in our sample documents. The other possible response is no response, that the defendant receives the papers and ignores them for whatever reason, maybe doesn't understand them or doesn't care about them or just does not care about the outcome of the case. And in that case, you're going to have to wait the statutory period before declaring that the spouse has defaulted in the action and that the judgment can still be signed, but on the defendant's default. And so you're going to want to wait within the state of New York. You're waiting essentially 41 days. On the 41st day, you can file final papers with the Supreme Court declaring that a default judgment should be entered against the defendant, granting a divorce to your client. If the defendant is being served out of state, you're going to add 10 days onto that period. The other possibility is that the defendant responds to the papers in some way. So that can vary very widely. Sometimes the defendant will call your office with questions about the case, and this is again a point of contact with her justice and perhaps with the partner at your firm who's supervising the case, or other attorneys on your team, to discuss what is appropriate and what is not appropriate to discuss with the pro se defendant. The defendant might file a notice of appearance, which requires then that you serve the complaint by mail on the defendant or the defendant's counsel if the defendant is represented. Or the defendant may do something sort of in between, like send you a letter saying that he doesn't agree to the divorce, or that he disagrees with the grounds for divorce, or that there's some form of relief that he's seeking. And, this might be a letter or an email, but not a notice of appearance, with a caption on it. And so that's a definite conversation to have with her justice mentor about how to be sensitive to an unsophisticated, perhaps, maybe pro se defendant in this case, and we'll talk through with you possible responses, and ultimately it'll be the decision of the firm as to how to proceed and whether the divorce is really going to stay uncontested.
All right, so after you have served the defendant and he's either signed the affidavit of defendant agreeing to the divorce, or he has not responded for 41 days or 51 days, then you can begin preparing the final documents. And this is going to be a large packet that's going to be submitted to the court. That is the packet that goes onto the desk of the judge or referee, and the judge or referee is going to review this packet, and if it's all correct, sign the judgment of divorce, and your case is done. As with the initial papers, this is going to be very important to be precise and consistent and accurate. So we're not going to go through each and every document in the packet. There are many different documents. There are more documents if your client has children than there are if your client has no children. As I mentioned before, there are samples of everything in your manual, and also Drafting Libraries creates most of the documents for you. A note on Drafting Libraries: if you drafted the initials using Drafting Libraries, I strongly recommend that you do not just use those documents that were spit out in the initial round as your final drafts, because certain other things may have changed. For example, you may have said in the initial round that you expected the husband to sign the waiver, but as it turns out, he defaulted. And the language in the finals is going to change in quite a few documents, actually, depending on whether this is a default or a waiver case. So it's generally a better practice just to rerun Drafting Libraries using the situation as it is when you're drafting the finals. It really doesn't take that much extra time, and it makes sure that everything in your finals is going to be correct. Refer to the checklists in our manual of which documents you're going to need and in what order they're going to be presented to the judge. Our checklists are on page 15 and 16 of our manual. And as I mentioned before, some of the documents that need to be included will not be generated by Drafting Libraries, and you will have to fill them, do a fillable PDF from the court website. And the links to all those documents that you need to download from the website are also in your manual. The clerk's office in New York County is very particular. They want things presented in exactly the order that they want them. So in our manual, we have included the checklist that comes directly from the New York court clerk. So make sure to present it in exactly that order. And the nice thing about the New York County matrimonial clerk is that they will review the papers initially before they even accept the finals for filing. They're not judges and they don't know the law, obviously, and so they're not reviewing your papers for substantive errors, but what they're doing is they're just going through quickly to make sure that every document that they expect to be there is there and in the right order. And if it's not there, then they might hand it back to your managing clerk to correct it before it's filed. This might be annoying, but it's actually doing you a big favor, because it's better to know ahead of time before you file that you have a document missing than to have the papers sitting on the desk of a referee for a few months and then have them bounced. On that topic, once the finals are accepted for filing, they are going to be reviewed, as I said, by a referee or a judge. And if your managing clerk is tracking the index number of your divorce on eTrack or eCourts or any other similar tracking system, they may alert you to something that's going to be called an appearance date. Don't worry about this, because generally just what happens in the eTrack system is that once a referee has a general idea of when they're going to look at your papers, that's called the appearance date. You and your client do not have to actually physically appear on that date. It is just a control date. So don't be alarmed if you get a notification from eTrack that your case is down for an appearance. When the referee reviews the finals, if he or she finds any errors or needs more information about something, then they may issue a defective papers notice. If you get a defective papers notice, don't panic. It doesn't mean that your divorce is not going to go through. It might be something as simple as, for example, the date on the affidavit of defendant didn't match up with the date that you put for service on another paper, and it's just a question of re-executing the documents correctly and resubmitting them. Once in a while, the referee is going to want more information. For example, maybe there's been a hit on the registry search that I mentioned. Maybe the referee found an order of protection in the registry that you and your client didn't know about. I've seen cases where the husband went on to have orders of protection filed against him by other people. So whatever the defective papers notice says and whatever it's asking for, read it carefully and see if you can respond by submitting a supplemental affidavit from your client. And you should be discussing this with your mentor as well. Send your mentor the defective papers notice and we can help you respond. 99 times out of 100, just responding with a supplemental affidavit will get the papers through, so don't worry about that. Clients, as I mentioned before, are always anxious to know when their divorce is going to go through. It's not up to you or us once the finals are submitted. It's really just up to the court. It depends a lot on what the volume of filings is. It depends on the time of year and on the borough. In Manhattan, it varies so widely. We see papers being signed anywhere from 2 to 6 months after being submitted. If it's been more than 6 months, you may want to call the court to check on it, or the clerk, just to see if there's been some error, but it can take up to 6 months. And then once your finals have been signed and they're ready to be picked up, you will have submitted with the final papers a postcard with your name on it, and the court will return the postcard letting you know that the papers are ready for pickup.
So there's a couple of very basic documents that are prepared even after the judgment is signed. You need to mail, just by regular mail, a copy of the judgment, the signed judgment, along with a notice that this judgment has been entered in the Supreme Court to the opposing party. And a frequent question that we get from the attorneys is, what if we don't know that the opposing party is still at that address, or that the address is accurate, that's not actually where he was served? As long as he didn't contest the address or correct it in any way along the way in his affidavit of defendant, that address is valid for providing a copy of the judgment. And know also that the defendant can always just pick up a copy of the judgment of divorce in the court file just by showing up at the court with photo ID. That's an important point to note also for the client. She may misplace her copy of the judgment in the future, and only the parties and their counsel can access that file. So it's otherwise private, from the public. You're going to present an affirmation of service and the notice of entry with a copy of the judgment of divorce attached to show that you did provide it by mail to the defendant, to the Supreme Court. And once that is filed, the case is officially concluded. We can provide you, incidentally, a fee waiver letter so that the cost of the certified copy of the judgment of divorce that your client will need can be waived. It's a much more modest fee, though, than the filing fees from earlier in the case, and so not every firm requests them, but we're happy to provide that. And once you have filed your notice of entry and your client has a copy of the certified judgment of divorce, the case is concluded, and we do recommend that you send your client a closing letter, explain that the case is now concluded, your representation is concluded, and it's important to sort of draw that line, because sometimes there is follow-up litigation in family court if situations change or custody or child support need to be adjusted, and it should be clear to your client that you're not on retainer forever to handle her family and matrimonial issues. She can always call her justice again or seek assistance at the Family Justice Centers, for example, but I think it is helpful to lay all of that out in the closing letter. We at Her Justice need a copy of the judgment of divorce once it's signed, and the file stamped notice of entry that shows that you filed the notice of entry with the Supreme Court. And when we have that, we will send you some case closing information, including some forms that will enable you to get CLE credit for doing the work. So thank you so much for viewing this training video. You're really doing such a great service for a client in our program who may not be able to accomplish an uncontested divorce on her own, or may really need the moral support, the helping hand of an attorney to get through this process and just begin the next chapter of her life. So we really do thank you for providing this service, and we are happy to be partners with you as your mentors as you complete your case. Thanks for watching.
Thank you.